Well, welcome back to Probate Matters podcast. I'm Jenny Dinker.
And I'm Erik Broel.
And we are going to talk about some probate situations, some interesting probate scenarios. Just so you guys know, we started this podcast as an addition to give more knowledge because our law office, Georgia Probate Law Group, only works in helping families that are going through probate situations, helping the families who've lost a loved one to make sure that the estate is settled correctly. So we wanted to do this to add some more knowledge out there for everybody to have that information. So we have Georgia Probate Law Group, and we actually have Guardian Probate Law Group as well, which is our Tennessee office. So we have our Georgia office and our Tennessee office. Today we're going to be focusing on the Georgia office and kind of going over some of those situations that our clients see a lot of times, and talking to you, Erik, about just how probate works and what all this means at the end of the day.
Yeah, great. That's awesome. So where do you want to start?
So I thought about this because we had our last episode, we went over a lot. And so I was like, what else can we talk about? But I know there's a ton more to talk about. So I wanted to maybe start today we talked about what probate is, but what does a more straightforward probate non-dispute look like? Like, what are those steps? And I think that's a good place to start for people to understand what that is typically looking like, basically, in Georgia.
Yeah, the basics.
Yeah.
The basics. Okay, so I describe it as 3 phases. Mm-hmm. I think that's the easiest way to teach it. So if we have a super, super simple non-dispute, everybody gets along, then legally, the process is in the first phase, we're going to go file a petition with the court to open the estate. Mm-hmm. There's different petitions depending on whether there's a will or not.
Yeah.
Then we're going to administer the estate, where we handle all of the property, and then we're going to close the estate. And so from a super high level, it's just really a 3-stage process.
Yeah.
There's all kinds of stuff that goes on in each one of those stages, but that's the simplest way to describe it.
Yeah, and that's how we, on the front end, when we speak to the potential clients, the 3 phases is the easiest way to think about it. And I think that really helps potential clients too, because I like to compartmentalize things because it helps me to not get as overwhelmed with stuff sometimes. And I think a lot of people feel that way. And one of the main emotions that a lot of our clients feel when they come to us, I mean, first of all, they've just lost someone. So there's a lot going on with that emotionally.
Absolutely.
To add on to that, now they have the overwhelm of probate and a legal process. And for anyone that's not an attorney, for most people I would say that are not attorneys, when you say anything legal, it makes people uncomfortable or it makes them overwhelmed. So when you could compartmentalize those 3 stages for people to say, let's start here at step 1. Let's get that step taken care of, because once we finish that step, it opens the door to the other things we're able to do. I believe it really helps people to not see it as, oh my gosh, there's this step, this step, this step. There's all these things I need to do right now at this moment, basically.
Yeah, I really like that. You know, I love to teach. And so I think breaking it down for someone, because you don't want to take an intimidating process and make it more intimidating. You want to take an intimidating process and you want to make it less intimidating. You want to make it simplified, because you want to take that client who's feeling anxious, or they're feeling the grief process, or they're feeling anger, or that they're feeling this loss, and you want to give them some level of comfort. Yeah. We can't change what happens. So there's nothing we're ever going to be able to do to make this situation good.
Yeah.
We're honestly taking a bad situation and trying to make it a little bit better.
Exactly.
That's the best we can do as probate lawyers. Mm-hmm. And so the way I like to do that is I believe that an educated person makes a better client.
Yeah.
And so the more we can educate, the more we can help folks understand and break this down. Like you said, this scary, intimidating legal process into simple phases or into simple explanations, the better it is. And so, sometimes it's hard because you can go really in depth on this stuff. But that's what, in my view, makes a good experience for the client, is in really understanding and not, reducing that anxiety or that overwhelm a little bit on our part. I mean, I'm a realist in that I understand we're not going to reduce it completely, because the client's still going to wake up in the middle of the night thinking, oh my gosh, what's going on with this, right? That's natural. That's normal, especially after a loss, especially if it's a loss, someone you really were close to and cared about. And let's be honest, the folks that would be handling the estate, they were probably pretty close to the person that passed away. Yeah. So they're experiencing that loss. And so, but that's a role we have in the process.
Yeah. And I love that. I've seen that with our attorneys when they have the strategy session with the clients too, how much they speak in just normal layman's terms, and they're not talking to them at some high attorney level, because that could be overwhelming too, because now your attorney's talking to you in almost a language you don't understand. And when you don't understand something, that's when you start to become more fearful and panicky, is because, just not knowing something can make it really scary at the end of the day.
You're going to get me on one of my soapboxes. It is so easy for anyone, and I'm not just going to say lawyers, for anyone who is in a field that is specialized. It could happen in medicine. It can be in engineering. It can be in the repairing AC systems. I've had AC go out at my house, and those guys can go over my head so fast in what's going on and the different types of fluids that can go into the system, or the different repairs and the different components. It's not just lawyers. It's any specialized field. And so for me, when we hire lawyers, when we train lawyers, and I'm very, very proud of our training process. We have a fantastic training process. That is a key part of it. Yeah, sure. We can go over somebody's head. Right? We can drown them in information that they don't understand really quickly. Good for you, right? That makes us feel smarter. It can make a person feel smarter, like, look at how much I know, but that's not true communication. True communication, in my view, is where you're able to take a very complex subject and break it down to where the average individual that you're talking to can understand it, and they can walk away and say, okay, I get it. I might not be able to completely explain it the same way you did, but I understand it. I get where you're coming from, and I understand why we have to go this direction and we have to do these things, and why we can't do those things. If we get to that level, then we've succeeded. And if a person wants to go beyond that, and they want to go into all of the technical things and get deeper, sure, let's go there. We can absolutely do that. But from a base level, in my experience, most clients, their eyes start to glaze over if we start to go in super, super deep, because most people they want to know the basics, they want to understand the basics, but they don't need to know how the sausage is made, and they don't really care. Some people do. We're happy to, we're happy to do either version of that, but I believe that explaining things in plain English is such a key part of any type of professional relationship. It's just huge. It's like going to the doctor, and doctors can go over your head instantly with all of the medical stuff. And then you don't understand a word they said, and they're trying to tell you how to take care of yourself. And
you walk away from that getting more nervous about what's going on, because now you really don't understand it. Yeah, I agree with you. I think it's totally about comfort. Somebody feeling more comforted from the time they came, before they came to us, by the time they came to us, like saying, okay, I feel more comfortable now speaking with my attorney, that I am at this place where I'm still overwhelmed, but not as overwhelmed. You'd mentioned the 3 steps, and the first step, of course, getting somebody appointed over the estate, going back to the probate process. What would you have as like your one piece of advice for someone that's named an executor who just found out that they're an executor?
Ooh, that's a good question. I think, so I'm always in the mindset of prevent disputes. That's where I start everything. Because the reality is probate disputes happen, and they take a long time and a lot of money to resolve, and then it becomes that story in the family. And so I've said this before, there's an opportunity at the beginning of the case to try to do everything peacefully. Sometimes that's a real possibility, and other times that was never a possibility, but maybe we give it a shot. So one area where I see executors go wrong, and this is going to sound really bad, they let it go to their head.
Oh, yeah. I could see that.
They let it go to their head, and then they kind of hold it over heirs or beneficiaries. We're going to do this my way. I'm in charge. And I would say to that person, let's use some softer tactics, because I think we're going to get more cooperation. And to the client, when I say more cooperation, what I mean is less expensive and takes less time. Right. And so most clients are very interested in less expensive and takes less time. And so more cooperation can help achieve that. But beyond that, let's try to prevent a dispute. Let's say we're in a scenario that's totally peaceful. I think the first piece of advice that I would give them is really, really read the will and understand what the will is asking you to do. That's very, very important. And so, for example, whenever we would look at a will, there's a few things that we'd look for. And these three things are going to have a huge impact on how long the case takes, how much is involved, how expensive it is, all that kind of stuff.
Yeah.
One is whether you're required to post a bond or not.
Okay.
The second one is whether you are required to provide inventories or not.
Okay.
Inventories and reports, I'll say there's a new reporting requirement in the past few years. And then the third is what level of power the executor has. And that's a whole interesting discussion because not all executors have the same amount of power.
A lot of people who call us think that they do.
Yeah.
They think they can pretty much automatically sell real estate once they're appointed, or even before they're appointed, but that's a different topic. But they think they have a whole lot of power that they just don't have every single time. And we have to tell them, our team needs to see the will first to understand what authority, that person has.
Yeah, you just raised a great one, and that slipped my mind. But the idea that just because you found your name in a will, that you can immediately start doing stuff, that's probably my number one. So thank you for that, because we see that not infrequently.
Yep.
A will is just a piece of paper until a probate judge says it's the official last will and testament. And what that means is the person who finds themselves listed as the executor doesn't actually have any power until a probate judge says they do.
Yes.
And the judge issues an order, and in Georgia, we call that order letters testamentary. And until those letters testamentary come out, you don't actually have any authority.
Yeah. Yep. It happens a lot. And that they think that they're going to be able to go in and start selling things from the house, having an estate sale, and we're like, whoa, slow down, you know. So I'm glad that your advice to them, though, is really read the will, understand it, and like we were saying earlier with like legal terminology and stuff, if you can't, definitely go speak to an attorney, I would say, to understand the more legal terms in it and everything. Yeah,
there's things that we're going to look for in a will that may or may not mean anything to folks.
Yeah.
The three that I just gave you are huge. If you have to post a bond, that's a whole different process.
Which is like insurance for people that don't know.
Yeah, it's like it's not a criminal bond. Sorry, I should explain that. It is not like a criminal get out of jail bond. This is more like an insurance policy that you get through an insurance company. It's a probate bond, and it's to insure the estate against the executor running off and doing bad stuff with the money. A lot of times those are waived in wills, but not always. And then your inventories, right? So like just imagine like a kind of a pedantic long list of everything in the estate.
Wow.
That has to get filed a few months after the executor is appointed. That can be waived by the will. Often it is, sometimes it isn't. And then finally, power. Man, that's a big one. An executor that does not have expanded powers, or what we call in the office limited powers, actually can't do very much.
Yeah.
They have the power to protect assets, the power to collect assets, the power to pay valid creditors or claims, and the power to make distributions.
Okay.
I didn't say sell the house, sell assets, those sorts of things. They actually don't have the power to do that. And that gets people hung up. I can't tell you. And this happens with administrators. I've been using executors because we're using a will example, but it happens even more in the context of an administrator where there's no will, because the will could give the executor all of these powers, power to sell real estate and all that kind of stuff. But with an administrator, unless you do something extra, you don't have those powers. And that gets folks hung up all the time, where they come in the office halfway through the process and and they're just kind of stuck. And it can be bad in the sense that, this always happens with real estate. They've listed the house for sale.
Yeah.
Right. They got the agent. They've listed it. They've got somebody interested. Right. And it always happens when the market's not in a good shape, and they get that person that's interested, and they think they're going to sell it, and they get the package over to the closing attorney, and the closing attorney says, "Whoa, wait a minute, we can't move forward.
You don't have the authority to sell this house."
Yeah.
Yeah.
So then they come running to us, and then we've got to scramble to try to get it done as fast as we can. But unfortunately, nothing in probate is fast.
Yeah.
And so our version of fast and getting a real estate deal done's version of fast are two different meanings of the word fast.
Yep.
That solving that problem can take us 30, 45 days. And that depends on what county you're in. And that's if we get the probate court to move quick.
Yeah.
And that's if everybody's getting along and they'll sign all of the paperwork we want them to sign that makes it move fast. There's some ways to get it done on an emergency basis, but especially on an emergency basis, we need everybody involved in the estate to be willing to sign whatever paperwork we need signed, agreeing to it. And in probate world, if we get that one person or two people that don't want to agree, it can throw a wrench in everything.
Yeah, I think that is a huge misconception also, because we've had a lot of people come to the office where they exactly what you just said. They're at the closing table, basically, and the closing attorney is the one that catches it and says, no, you can't sell this house, and they want it sold by next week.
Yeah.
And so we do have to, basically give them a more realistic idea of a week's probably not going to happen, but our team will do everything they can to expedite it as much as possible. But like you said, the court takes time to approve things.
Right.
So that will take some time on that. I like that. I think that's really good information for the executor to know. Just read the will, understand what you can and you can't do on the front end pretty much.
Another big one that sometimes drives us nuts, and this is a situation where there's a surviving spouse, right? It's the first spouse to pass. The will, in Georgia, we've got this thing called years support, which is our spousal support statute. We can go into that later. But the will can force an election between getting what's under the will or getting years support. And that's always important to know if that's in there.
Yeah.
Because that can change what we're going to do in the process. That can change decisions we may make. The other thing to be aware of, and this really isn't the executor, this is more this is more an unhappy heir, is identifying whether there's a no contest clause.
They call it a kick-out clause sometimes?
Yeah, kick-out clause, no contest clause. The formal word is in terrorem clause, which is, I think it's Latin for in terror of or something like that.
Okay.
That's where it comes from. But basically, if there's that type of clause, it means if you challenge the will and you don't win, you're out.
Yeah.
And those clauses can come in all different shapes, sizes, flavors. And so some can be super strict, some can have a little bit more wiggle room in them. And so you gotta, if that type of clause is in there, you gotta read it real careful, whether you're the executor or an unhappy heir or an unhappy beneficiary heir with the will, because even filing the objection can often trigger that. And so you gotta be careful with it.
That's I did not know, actually. You just said something that made me think. For the no contest clause, I was always under the assumption that if it's in the will, that it pretty much always says the same thing: don't contest the will or you're going to be kicked out, or you don't receive an inheritance. But you said they could kind of be more strict and everything. Can someone ask questions about the estate? Like, let's say that the will's already accepted. Would that no contest clause apply to people who have questions later on if they feel like the executor's not doing good things? Because we have a lot of people who are under that idea that since it said it in the beginning, I'm not allowed to ask questions at all because there's a no contest clause in this will. So I got to keep my mouth shut, basically. Yeah. Is that true?
That's a great question. I'm going to say, generally speaking, that is not true. So we make a difference. And this is an interesting area of law. And I cannot give you like firm definitives on all of this.
Yeah.
But generally speaking, for most no contest clause, and you raised a great point, there's not like one paragraph that is identical that gets put in every single will. And that's the reason for my hesitancy in answering the question.
Yeah.
Because you've got a whole bunch of different estate planning attorneys that write wills. You've got online services that will let you download documents. And so they're all written differently. And that's what creates a lot of the difference in how we handle things.
Yeah.
That and the family members and their behavior, right?
Yeah.
So generally speaking, in a no contest clause, often I'll say, before the will is accepted, because we'll make that distinction you made, before the will is accepted and after. Before the will is accepted, you can sometimes or often challenge the identity of the executor if you've got good cause.
Okay.
But you can almost never challenge the piece of paper itself, right? So what does that look like in practice? Well, you can't say, I think this will is invalid. Right? That's going to absolutely trigger the no contest clause almost every time. You could say, I don't think Jenny's going to do a great job. I think there's some things in the background, like the other 3 estates she stole money from, that means she's probably not going to do a good job in this estate either. And depending on how it is done, you are sometimes and often able to get that kind of argument through.
Okay.
Now that's before the will is accepted.
Got it.
After the will is accepted, again, we're still dealing in the same dynamic, but now that our executor is appointed, yeah, almost always you're going to have the ability to review their actions for the purpose of making sure they comply with the will. So you see the twist there.
Yeah.
We're not challenging the will. We're actually doing the opposite. We're saying, hey, the will says X, Y, and Z, and we think based on our reading of the will and looking at what you've done, we're questioning whether you're complying with that.
Yeah.
And so we want the will enforced, and we want the will to be honored exactly as it is written, and we want our loved ones' wishes to be respected, and you're not doing that. And so we want to look into what you're doing, or we have questions whether you're doing that. And so we want to look into what you're doing. And there's mechanical legal processes to do that. We can file a petition for accounting, for example. That's a common one that gets used for that purpose. And then you could even go so far as to file a petition for removal and to ask the court for other relief and other things that you want based upon that executor's bad conduct.
Yeah.
And I think the difference here is, challenging the will and challenging the desires of the person who wrote the will, who's now deceased, versus taking the position that you want the will enforced and we're for the will, but we're trying to prevent bad actions that we now have evidence of or we suspect.
Yeah. I think that's a great explanation of that. That is, and you have to look at the before and after. You have to look at that, because from what I see a lot of times is filing a caveat, filing the objection to the will, that takes place in the beginning before the will's been accepted. So that is contesting the will. So that would make that clause come into effect. Whereas once the will's been accepted, that's done. That arena's that's finished. There's no, I won't say there's no, but it's rare to go back to that to say, well, now I want to contest the will now that it's been accepted, basically. Now you're just asking questions about, like you said, the will's valid. Nobody's saying it's not, but we want to know, what are you doing? Where is everything, basically?
Absolutely.
Okay.
Now, let me go back to something you just said. You said about after the will's accepted, can you go contest it? Let's forget about the no contest clause.
Yeah.
That's just going to muddy our issue, right? Because we do have folks that ask that. That's a not uncommon one that comes up. My brother filed the will. It was accepted. I agreed to it, 6 months ago. Well, now I'm not so sure about it. Or we were digging around and we actually found a newer will.
Yeah.
Right?
Yeah.
What happens? Can you go back and contest the will? That's hard. Can you do it? Yes. Is it easy? No. Because you're out of time. And what I mean by out of time is when a will is filed, if you consented, and this is so important, if you consented to that will being filed, then you're agreeing to it. Going back and challenging it after you've agreed to it and like withdrawing that consent can be very difficult. I'm not going to say it's impossible. We have done it. Like our team has done it. We have seen other folks do it. But you got to have a good set of facts.
Yeah.
And what I mean by I'm using legal lingo. When I say set of facts, you've got to have good reasons for it. We've got to be able to explain to the court why you agreed to it to begin with and what changed and why you want to challenge it now.
Yeah.
A good set of facts would be, well, we found a new will, right?
Yeah.
We found a newer one, looks valid to us, we're going to file it. And maybe so-and-so hit it, or maybe it was just put in a different location, who knows what reason why. But that would be one where we could go back and we'd file a new will, which is a little bit different than challenging the old will. If we were to challenge the old will, we would need to get permission from the probate court to even file our objection at that point because the time period's passed, especially if you agreed to it. So first you got to go get permission from the court to even file your objection. Then you file your objection. And then you go down the path of having the court rule on your objection. So you've got multiple hurdles in your way.
Yeah.
And whenever you look at a dispute, a legal dispute, one of the filters or lenses I like to look at is how many ways do I have to win and how many ways does my opponent have to win?
Okay.
So here, if I've got to get the judge to agree to let me file an objection, and then I file it, and then I've got to get the judge to agree to agree with my objection or rule in my favor.
Yeah.
My opponent has to win one of two. I've got to win two of two.
Yeah.
Right? So it puts
It's more of
me,
an uphill battle.
Yeah, puts me in a worse position.
That makes sense.
Unless my facts are really good.
Yeah.
You can win two of two on great facts.
Yeah, exactly. Yeah, I had someone who spoke with me not too long ago, and they wanted to potentially contest a will that was accepted about 12 years ago.
Wow.
Yeah. It's still bothering them.
Yeah.
But it's been accepted. And they really felt like in their heart that it was wrong and that it's not supposed to be there. So I believe that's what you mean by also with the time period. I mean, if it's been a long time, 10, 12 years, I could see that being more complicated than if it was just 6 months ago that this happened.
I'm not going to say you can't do it.
Yeah.
But I think we've got bigger practical problems here.
Yeah.
If that will was accepted 12 years ago, does the estate still have anything?
That's a good question.
Has it either all been spent or dispersed? Or, we're way past. And when I talk about time, just to clarify, the objection period's 30 days. Mm-hmm. If you don't agree to a will and sign off on it, then the court's going to have to send you notice. This will has been filed. Here's a copy of the petition. Mm-hmm. You have 30 days. Yeah. So you're talking about 12 years. That's a lot of time.
Yeah.
I mean, a lot can happen in 12 years.
Yeah, exactly.
So if I was looking at that, my first question is, before I even get to any of the legal stuff, I've got a practical question. Mm-hmm. Let's assume we can win everything, which is a big if, but let's assume it. Mm-hmm. Is there anything left to get?
What's left there? Yeah. Well, and after real estate's been transferred and everything, that's very complicated, I would assume. If that's already been distributed to someone else, and then that's down the road at that point.
Yeah, you're talking about a super complicated case with a lot of steps. And honestly, a low likelihood of winning and a big bill.
I saw one on the opposite side of that, actually, that you brought up a point about finding a new will. I found that I spoke with someone about 6 months about that. He was in his dad's house and just going around, and he found a more recent will.
Oh, that's
and
cool.
The other will had been accepted, but he was more than prepared to produce this one that was very different than what the one that was there. So I could see that one being a more of a place where we're saying, okay, we may have a little bit more on our side to at least go with, depending on what the will looks like and everything else, of course, with that. And that not as much time had went by, not 12 years. It was more like 3 months or something like that, 3 to 6 months. I was going to ask you this, Erik. You talk a lot about, you're really focused on preventing disputes on the front end. You mentioned that a few times. You're like, all right, that's the first thing I go to is how can we also prevent a dispute so this doesn't go the wrong way? How would you suggest for that executor or that administrator or just the family in general to start to have those open and honest conversations? And when is the right time? Because that's another problem is some people say, well, I don't want to talk about the inheritance just yet. They just passed 2 weeks ago, 3 months ago. When do you feel is the right time and how do you have those conversations?
I'd say get through the funeral.
Mm-hmm. Yeah.
Sorry, if you got somebody that's trying to talk about that kind of stuff before the funeral, it always makes me wonder a little bit.
Yeah.
It's natural to come up, though. I mean, it's natural. Okay, what are we going to do with the house, right? If it's those kind of conversations, what are we going to do with the house? What are we going to do with this? Okay, that mortgage has got to get paid. That's more let's get together and let's plan type conversations.
Yeah, exactly.
Versus a conversation of, well, I've been thinking. And, I really think that I was there for Mom a lot and you weren't. Mm-hmm. That's a different type of conversation.
Yeah.
And so I would think if it's possible to have a family meeting after the funeral, maybe even a day or two after, especially if people are traveling and you've got everybody there. I think these kind of things happen face-to-face can be important because body language is important. Text messages, emails, it's so impersonal. Tone is often lost. They're often misinterpreted. Yeah. Phone calls are a little bit better, but sometimes you just need to have an in-person conversation. I think this is one of those times where that can be very, very beneficial. And then how you approach it, I would say with gentleness and transparency. Yeah. What I have seen, what we have seen in the office time and time again, is if you have a situation where a person is not being transparent. Mm-hmm. Maybe they were a caretaker and they're not being open about what the property is or what happened. That automatically causes suspicion on the part of other family members, and then that suspicion leads to conflict.
Yeah.
And so, and I guess it's kind of the old, if you don't have anything to hide, why are you trying to hide it?
Exactly.
So that's where I would say from a dispute prevention standpoint.
Yeah, I like that a lot. Something I noticed a lot during COVID specifically that I thought was good that actually came out of that time period was that families that were all over the country would get together on Zoom more to talk about estates and situations like that. And like you said, now that's face-to-face, kind of.
Yeah.
I mean, obviously on a screen, but more personal than a bunch of text messages or emails or no social media, in my opinion. Don't post it on Facebook about what you're upset about. It just puts a whole different tone to it. And people get very upset about stuff like that, understandably so.
Yeah, and it could be used as evidence later. I mean, let's...
Oh, yeah. See? Yeah. So they can like screenshot that and say, look at all these things that were said and done. Yes, I also saw at one point, or didn't see, we've gotten calls before of people who are selling estate property on like Facebook Marketplace and things like that before the person's even appointed, and then they're selling, different items from the garage or whatever on Facebook Marketplace. I'm just like, why would you do that?
Yeah, so let's talk about that for a minute, because that's interesting, right? Because we've talked about how I feel about trying to prevent disputes, right? Sometimes you just got to deal with people aggressively. And it sounds like I'm talking out of both sides of my mouth. But you've got to take the situation as it comes. And if we've got a situation where a person comes in and you have someone in the family that's actively stealing or trying to steal, we're past trying to prevent disputes.
Yeah.
We need to act aggressively, and we need to act immediately to stop that. Particularly with personal property. Personal property is such a sticky issue in estates. And the reason I say it's a sticky issue is because a lot of times there's a tremendous amount of emotional and sentimental value in the personal property. It's also usually not worth a lot in the real world sense. If I was going to try to sell it in an estate sale,
the monetary value.
Yeah, it doesn't have a lot of monetary value, but it's got a tremendous amount of sentimental value. Well, if you get somebody, and we've literally had this situation where the family's at the funeral, and except for one family member who is at the estate home with a U-Haul, what do? Well, once that personal property is gone, it's gone. It's hard to get it back. It's hard to prove it existed unless you've got photos or video or stuff like that. And it's not from a damages standpoint, right? Because in the legal system, we work on money damages. It's not worth a lot. So can we take action against that person? Yeah, we absolutely can, and we do. We've got a cool thing in Georgia called Executor de son tort, I believe, and it might be Sunday. I always mix those two words up.
Son tort, I believe.
Is it son? Yeah. So that allows us to get double damages against a person who was acting like an executor or who asserted control over the property, but then, messed it up basically. Or it goes a little beyond messed it up. Like they intentionally took something. They were doing bad things that they shouldn't have been doing. They had no business doing. And so we can go after them. We can get double damages. But at the end of the day, I'd rather act aggressively on the front end and try to stop it if at all possible. So it's interesting because you get some folks that wait too long before they do something, and you get some folks that try to act too early, right?
Yeah.
And so we try to help counsel folks. So are we acting in the right way at the right time?
Yeah, and that's really good information. And that you said that about somebody being at the estate home while everybody else is at the funeral, and it's so sad when that happens because those items, like you said, they are hard to track down, maybe impossible to track down. What if you kind of have a feeling, and I don't want to go too deep into this, but just thinking off the top of my head, if you have a family member who you kind of have a feeling is going to be that person who's going to be going to the estate home and taking things, is there anything that someone can do to try to prevent that in any way beforehand? Or are they pretty much just like, let's just hope it doesn't happen and go from and try to get recourse later on in some way?
Yeah, practically, I mean, here's the problem. Nobody has authority over that house. So we're down to practically kind of the Wild West. Who has access? Yeah. What can we do legally? There's emergency petitions we can file to try to get someone appointed over the estate very, very, very quickly on a temporary basis. And then that person would have the authority to go change the locks. Okay. That's one of the best plans. Yeah. Now, again, it's a temporary appointment, so we're going to have to go back and do everything over again. But if we're worried that the estate property is going to be harmed, taken, stolen, defrauded in some way, then that would be our first go-to, is go get an emergency petition filed, get our client in a place where they have the legal authority to act, and then have them go change the locks and kind of lock down the house. Yeah. And inventory everything. Like I love, video inventories and formal inventories. Okay. That kind of stuff can be really good, right? And even if you don't have authority, going through the house, taking a video of everything, I mean, that's useful. That at least helps prove what was there at that specific time.
Yeah. Versus what this person may say later on of, oh no, that drawer was never there, or that was never there, and they've already moved everything out basically, or pawned it or something else at that point, which makes it really difficult.
Yeah, the other dispute you can get into that we've seen there is someone will say, well, yeah, that was in the house, but it was mine.
I could see that. Yeah.
Or Mom gave that to me right before she died, told me to go to the house and get it. So it was a gift before she passed away. So it's really mine. It's not really estate property.
Yeah.
So we get into debates about that.
What about, that just made me think of something else. What about with, I hear this a lot, husbands, wives, and then let's say the wife is not the mother of the kids, so evil stepmother sort of scenario that we hear quite often. How did people divide up their personal property? Because you'd think that they were married, but this was dad's, this is hers, that's not hers. What do we do in those situations?
Oh, it's tough.
Yeah.
Oh, it's tough, especially if the family doesn't get along. Because personal property isn't a titled asset.
Okay.
So you have to ask, well, what was his, what was hers, what was ours? And so depending on how long they've been married, right? Like if it's a very, very recent marriage, that's a lot easier to sort out than it is if it's been a long-term marriage. But we get in arguments over it, especially the valuable property.
Yeah.
Now, if it's a title asset like a car or a home or something like that, that's relatively easy.
Makes it more straightforward.
Yeah, it makes it more straightforward. You'll still fight over it, but at least the starting point is straightforward.
Yeah. I remember years ago that probably, and this was the one that always sticks in my head, the wildest situation I've heard a family fighting over was some shoes, actually.
Yeah.
Believe it or not. And people don't think that. People always automatically think it's about real estate or money. But no, these shoes were very important to all the family members, and they were fighting over who gets his shoes, basically. Yeah. And it went through a period of time until there was some sort of settlement. But yeah, personal property comes into play big time with people, and you don't know what emotional and sentimental ties someone has to that for a very good reason. Maybe that gives them a memory of some time they had. I had a situation more recently where this person who came to us, and I hear this often as well, there were these properties involved in the estate, and there's a step-parent involved, and she didn't mind if the step-parent had 2 of the 3 properties, but the one property she remembered growing up in with her grandmother and things like that. Her mom was there, but her grandmother really raised her in that house with her, and so it was really that one house. She told me it's not about the money. She doesn't need the money, she said, but that home held such a high sentimental value for her that she had to do something. She couldn't let the step-parent take all of the properties, basically, at that time. So sentimental value, that emotional tie is really strong. I think a lot of people don't put enough emphasis on that sometimes.
Yeah. Yeah, I can totally understand that. I mean, I remember a case in particular we had where it came down to a fireman's hat. There was a number of kids from a number of different relationships, and that's what the entire case came down to. Figuring out how to split up money once you get to the bottom of it. Is not nearly as difficult as trying to figure out how to split up a pair of shoes, a fireman's hat, or a particular piece of property that's very, very sentimentally valuable.
Yeah. We had talked about on the front end how to prevent disputes. When you're an executor administering the estate, working through it, what suggestions do you have for them at that time to try to keep disputes from popping up, basically?
Be transparent.
Yeah.
Number one, absolute, be transparent. Answer folks' questions that are reasonable. And I say reasonable because you get unreasonable people, especially in family situations. But, providing a summary to everyone about this is what we have, this is what the estate has, and this is how it's going to be divided pursuant to the terms of the will or pursuant to state law. That can go a long way. And then I hate to say it this way, but just avoid doing shady things.
Yeah.
We've had executors that want to live in the house rent-free for years. Yeah. Oftentimes, we're not representing the executor. We're representing an heir that's upset about that. Yeah. And we need to get the executor out of the house, or their kid, or whoever is staying there. Those are the kind of things where people just get really upset, and rightfully so.
Yeah.
If you're supposed to inherit a portion of the house, and the person that's supposed to be in charge of that estate and be responsible and be ethical and above board is taking advantage of the situation, that's not right.
No.
And so, but my number one to prevent disputes and try to keep everybody on board is just be just be forthright, just be transparent. And we would coach and advise clients in that way as well. We like to provide updates to the family, written updates so that they know what's going on.
Yeah.
Because by and large, when you've got somebody that you leave in the dark and you don't answer any of their questions, they just naturally get suspicious, and it causes unnecessary disputes.
Yeah, yeah. Which is another question we get a lot is, when should someone, well, this is a two-phrase question, I guess. So one way is, how long is it supposed to take to go through probate? Let's just start there.
12 to 18 months, I think, is a safe bet.
Okay.
12 to 18 months, normal, everybody signing off on everything, kind of simple probate. Sounds like a long time, right? Mm-hmm. So the reason why is because there are built-in delays in the process. So imagine you file the petition, and then a notice has to get put in the newspaper that runs for 30 days. Mm-hmm. And then you begin working on the estate. The creditors, once you open the estate, a creditor period begins. That has to run for 4 weeks. You put a notice in the newspaper to them. That's got to run for 4 weeks. And then their creditor period lasts another 3 months. Well, I got 4 months right there. Mm-hmm. We can be doing things during that time period, but we often don't, because we want to let the creditor period run right before we really start making distributions and whatnot. Well, if you just add those up, I got 5 or 6 months just between getting something filed and a couple of notices in the newspaper. And then we have to sell the house. If there's a house, we have to take care of the other property. That takes time, whether we're going to have an estate sale, we're going to donate to charity, whatever. We're going to divide it up amongst the family. And then we have to close the estate. And closing the estate takes another 30, 60 days, just like opening the estate. Mm-hmm. Now, quick disclaimer, you're not required to close an estate in Georgia, so I don't want to have anybody thinking I'm saying you must. Strongly recommend it. Yeah. There are very strong legal reasons why I would recommend you close an estate, but are you legally required to? Nope. The statute does not say that you have to close an estate. It is just very strongly recommended. Yeah. And so by the time we're done, we're easily 12 months down the road, 18 months down the road, depending on different assets that are in the estate.
Okay. Before I ask my other question, to add on to what you just said there with you don't have to close the estate, I think this is important. You don't have to close the estate, but let's say you're one of those with the limited powers and you're required to file the reports each year and your bond has to be kept up each year. That doesn't stop. So eventually, if you don't close the estate, you'd still have to do that, right?
Yeah, that's right. Yeah. If you get rid of all the property in the estate, your bond will be zero, so you could potentially stop that. Mm-hmm. The big reason why, I'm not trying to play hide the ball, the big reason why we close estates, and we like to close estates, is because Georgia's got a really good liability protection statute. Mm-hmm. Okay. And if you close the estate, you can do it in one of two ways. You can do so where you discharge your executor administrator. Mm-hmm. That's way one. The second way is you can discharge them and protect them from liability for anything that happened while they were in office. Obviously, we're always going after the second one. That's what's good for the client.
Exactly.
Well, that's pretty good. Mm-hmm. I mean, that can give someone a lot of peace of mind, because there is risk in being an executor or being an administrator. And if you mess it up, you owe duties to the estate, you owe duties to the creditors of the estate, you owe duties to the heirs, the beneficiary of the estate. Like, you've got to manage this. Mm-hmm. Mm-hmm. Being able to tell that person, hey, we think we did all this right, we're going to close the estate, and getting the probate judge to sign an order saying, yep, anything that happened during that estate is past, that's water under the bridge, you're good, you can go on with your life. That's a lot of relief for people.
Yeah.
I'll just give you the counter argument. The counter argument to not closing estates is, well, what if we find another random asset? What if we get a check-in and it says to the estate of, now we can't do anything with it? My answer to that is twofold. One, that's kind of rare. If you did your job well while you're managing the estate, that shouldn't happen that often.
Yeah.
And B, if it does happen, there's a process we can go through to reopen the estate and then get a new estate bank account. Yes, it's another annoying legal process, but when we look at the percentage of times where we need to utilize that process versus the percentage of times we don't need to utilize that process, compared with leaving it open and leaving liability exposed versus closing off liability, 10 out of 10 times I want the client to close the estate.
And usually that's faster, than the whole probate process if you have to get a reappointment. You're not saying you're going through everything all over again.
Correct.
You just need to at least get that person back into their position of authority to manage the estate. Okay.
Yeah, you've checked a lot of the boxes at that point. You're just trying to deposit this check or, deal with this piece of property or whatnot.
Okay. Yeah. I could see how closing it with that liability shield of sorts would be It's just more relieving for people. You know,
Yeah.
you have a sense of closure that it is actually finished
Yeah.
and you're done with it at this point. So my other part of that question I had at the beginning was, so we talked about how long the process typically is if it's a non-dispute. So when do you think that people should, if they have some hesitations, like an heir has some hesitations about what the executor is doing, when is a good timeline to start asking questions about that if they're not getting much information? When do you put that pinpoint? I know every situation is different, but if you had to kind of just overview it in some way.
I'd say be reasonable about it, but be firm. So I think it would be totally reasonable if you start informally, hey, I'd like to get some information on this estate, on what's going on with mom's estate. Can you let me know where we're at? You get nothing. Well, then you have to ask a little bit more formally. Hey, I asked you about this. Could you please send this to me?
Yeah.
You get nothing. Hey, if you don't send this to me, I'm going to have to take more aggressive action. You probably wouldn't say that. It's a very lawyer thing to say, but I'm going to have to figure out, I need to know what's going on. At that point, typically that's when folks come to us a little bit exasperated, like I've tried everything I can think of. What can you do to help me, right? That's always the question. I'm going to get a lawyer. What can you do? We'd usually recommend starting with a similar process, but more formal from us. Phone call, letter from an attorney.
That letterhead speaks volumes sometimes.
Yeah, we need this information. And then we would put the lawyer language in there. If we don't get it, we're going to do bad things to you. So, please send it to us. It'd be really nice.
Under this statute, you need to be doing this. Yeah.
Exactly.
Yeah.
It'd be really great if you could just send this to us now and we don't have to go do bad things to you.
Yeah.
Right? In lawyer language.
Exactly.
But that's essentially what we're saying. And so if that doesn't work, then we file something. The ultimate way to deal with it is we're going to go to the probate court, we're going to file something, and we're going to cause the executor to be hauled into court and answer questions.
Yeah.
A lot of times, we'll be able to get reports ahead of time through an accounting or some procedure like that. And then that will typically end with a hearing where we will have the executor there and we'll have our stack of records, or even worse, we don't have a stack of records, and the entire conversation with the probate judge is, why don't we have a stack of records to go through? That's never good for the executor.
Yeah.
Especially if the judge has already ordered them to produce records and then they just didn't. You don't want to be an executor in that situation. But if we've got our stack of records, we're going to go through them. And we're going to talk about what's going on in the estate. And so there are ways to go get that information. There are ways to protect the estate. And we have some great probate judges in Georgia. And our judges are really interested in making sure that the estate is protected. So if you've got a bad acting executor, they'll often give you a chance or two, but it's not going to go far beyond that, where you're going to get a removal. And, we've got the ability to ask for additional sanctions. It's not just, we can get the executor removed. We can go after additional sanctions, additional damages within the probate court itself for an executor that's acted badly.
Yeah, so they could be held responsible,
Absolutely.
essentially, for all of that.
Yeah, we can get damages against them. It can be used to take away portions of their inheritance. If their inheritance is insufficient, it can go beyond that into their personal assets outside of the estate.
Wow.
Yeah, I mean, an executor owes fiduciary duties, and that's another legal term. But a fiduciary is the highest level of relationship that there is under the law. That means that as a fiduciary, you've got to put the interests of the estate, its beneficiaries and heirs, above your own.
Yeah.
And so if you're doing bad things, if you're taking money, hiding assets, moving things around, providing it to other family members, you can be held responsible for that. Generally speaking, when we get an executor that we've gone to these links and they're still not providing documentation, it's because either they don't have it because they're super sloppy, which is probably going to cause problems, or they're doing bad stuff, and we've got to pursue them aggressively. And we have no problem with that. I don't want our listeners to think because I talk so often about how can we prevent disputes that we have a problem with them. We don't. We litigate exceptionally aggressively. But it's one of those things, and it's one of our principles as a firm. We want to do what's right by the client because, we're fiduciaries to our clients.
Yeah, I could see that.
So, sure, litigation generates a bunch of legal fees. That's great. But what's right for our client even if they don't want to hear it, sometimes the right advice is there a way we could do this like a little bit more peacefully?
Exactly.
And if there's an opportunity to do that, great. If there's not, absolutely, we'll go to town, we'll litigate.
Yeah.
It's not a problem at all. We've got really good litigators.
I was about to say
that's
they know what they're doing. So if it needs to get aggressive, they can get aggressive at that point. Or if our team looks at it, I've seen this situation. I know you said that many times we want to start with the demand letter if possible, things like that. But I've seen in some situations where our legal team will look at it at that strategy call, go over it with the client and say, we're wasting time to start with the demand letter in your specific situation. So you know what? We're going to file against him in about 2 weeks, 3 weeks, whatever the time frame may be. But we're going to file as soon as we can so that wakes him up to what he's doing, basically.
Yeah, you're right. It's all situation dependent, and it is all after looking at the case and looking at the client and the situation, like what is best for this situation. And that's why it's not cookie cutter. We can't put it in a box.
Yeah.
It's every situation is unique.
Very different. And we're going to get into a lot of those. I feel like going through with this podcast, we're going to talk about a lot of those different situations. And I hope that helps people to realize that they really aren't cookie cutter. Like when you hear one, you're like, oh, wow, that's very different that happened in probate. Yes, it did. And then this so I think having that knowledge out there is going to be really good for the listeners. Yeah. Cool. This is fun. Well, Erik, I think that's about it for today, but we'll pick it up again next week.
Awesome. I appreciate it. Well, thank you very much.
Thanks. All right, bye.
Bye.